A very good morning, everyone. Atal Misra this side, and we are starting with our new unit, that is Indian Partnership Act 1932. It was enacted before. Enacted by the British Parliament. Again, overview to the Partnership Act. It governs the partnership in the partnership throughout the country. It defines the relationship between the partners and regulates the formation of partnership, operation of partnership, and dissolution of partnership. And its application is not just restricted to the registered partnership. It also regulates the unregistered firm as well. Then we have section 4. It gives the broad definition. So section 4 covers the definition. Partnership with the relationship between the person who have agreed to share the profit of the business carried on by all or any of them acting for all. Elements. What are the elements? First one is agreement, formed by the agreement between the two or more individual. There would be the profit sharing, and then there would be business activity. There must be a business activity. Then there is a mutual agency. Each partner is an agent of the firm and can bind the other to in the transaction with the third party. Again, nature of the partnership would be not separate legal and not a separate legal entity, based on the mutual trust and cooperation and shared goal. Then we have the step for the formation, which is agreement. Partner must agree to form a partnership on an oral or written agreement. A written partnership deed is preferred by the clearly and legal protection. Partnership deed, a document outlining the key terms and conditions of the partnership firm, which basically addresses the name and the address of the firm, nature of the business, capital contribution of each partner, profit, loss sharing ratio, duty, obligations, and of the partners, and duration of the partnership if it is fixed, of course. Again, registration is optional, and the registered firm enjoy advantage in the legal proceedings as we and the rights of the partners. What are the rights? So basically, the first, to participate in business. If the partners have right to participate in the business management and operations, to share the profit, the partners share the profit as per the agreed ratio or equally if not specified. Then right of indemnity. Partners are entitled to be indemnified by the firm for the liabilities incurred in the ordinary course of business. Then we have right to access the books of the account. Again, these are the exclusive right of the partners to access the whatever books and they inspect the copies of the firms of the accounts. Then we have right to continue the business. The partner have right to continue with the business if it is not dissolved. Now, what are the duties of the partner? Duty to carry on the business for benefit of the firm, which is discussed under section 9. Partner must act in good faith and best interest of the firm. Again, duty to render true accounts and information. Partner must provide the full information regarding the business to the other partner. There must not be any ambiguity or any hiding of the fact with respect to the partnership firm is concerned. Again, duty to not to compete. Partner cannot engage in a business activity that compete with the other without the consent of the other. Otherwise, it would again we see the very purpose of the partnership. Duty to act on good faith. Again, partner must be contrary to the interest of the partnership. Duty to contribute capital. Partner are required to contribute capital as per the partnership agreements. Then we have liabilities on partners. It is most important concept which need to be discussed. It has also been included under section 25 of the Partnership Act. Partner are jointly and severally liable for the debt of the firm. Liability in case of new partner, section 31. New partner are only liable for the debt incurred after their admission. There is no what we can say, there is no prior past liability on the new partner. So it has been already been categorically discussed and mentioned under the act that new partner's liability would be set upon the moment, the time when he joins the firm. Again, liability in case of retiring partner. The retiring partner are not liable for the firm debt after the retirement unless otherwise agreed. If there is an agreed agreement between the partners, that is exception. But if the partner retires from the firm, then the debts liability doesn't include him under the liability of debts. Then personal liability: if firm cannot pay its debt, then personal asset of the partner may be used to settle the liability. Then we have types of partnership. General partnership: our partner are share equal responsibility for the business and its debts. Then we have limited partnership. Some partners have limited liability, and their responsibility is confined to their capital of investment. As we all know, every partner, there must be situation that partner but be the sum of amount which partner is contributing to a firm may vary. In those situations, the capital investment which is being made by a specific partner, the liability on him would be according to it only. Partnership at will: no fixed duration. The partnership continue until it is dissolved by the mutual consent. Partnership to the fixed term. A partner perform for the specific period of time. And next we have dissolution of partnership. Section 39 to 55. Dissolution occurs when the business ceases to operate or when a partner is no longer involved. The ground of dissolution: agreement. Section 40. Partner are mutually agreed to dissolve the firm. Compulsory dissolution: it occurs when business outcome unlawful or illegal. Again, court order: court may also order for the dissolution of any partnership firm. A court may order dissolution in like case partners incapacity or permanent breach of duty, etc. And fifth one is expiry of term, which is discussed in the section 42. Dissolution occur after the completion of term agreed in a partnership deed. Then we have debt or insolvency of the partner. In case there is a debt or insolvency of the partner, it may cause the dissolution unless the partnership deed provide otherwise. If there is an exception, then it would be dealt according to that, otherwise it would be dissolved. Then we have effects of dissolution. What would be the after effect of the dissolution? It occurs when the business ceases to operate or when when a partner is no longer involved. Ground for the dissolution: first, there may be an agreement according to section 40. Partner are mutually agreed to dissolve the firm. Then compulsory dissolution occurs when the business become unlawful or illegal. Court ordered. Expiry of terms: this we have already discussed. Partners. Then we have partnership deed. A written agreement or outlines the right, duties and obligation of the partners. And what is it's important, it prevents dispute. In case there is a dispute, then it would be dealt according to the terms and condition which has been written in the partnership deed. Again, it define the key aspects: the capital contribution, profit sharing and exit condition. So in the partnership deed is said to be an important document which defines all the key aspects of an partnership firm. Again, governs the relationship, serve as the foundation for the management of within the firm. It sets a foundation between the partners of the firm. Then we have the landmark case on this in this regard. There is Meghraj Kotari versus Golakchand Agarwal 1997 case. Dissolution of partnership due to disagreement among if the partners are disagreeing, there is a disagreement among the the partnership firm can be dissolved. Then court ruling that dissolution of the partnership based on the conflict between the partners. Then there is Lalchand versus Motilal 1998 case. Dispute or liability of retiring partner. Court ruling addressed that extent of liability of retiring partner, highlighting the term partnership term of the partnership agreement. So that's all from